So good morning good afternoon actually to everyone. Welcome to this workshop on digital regulations in the EU, digital regulations in networks and platforms in the EU. And we are here to hear from our specialists, our guests, Thomas Lohninger, who is Director of Epicenter.works. Thank you very much, Thomas, for being with us. And Barbara Lazarotto, who is researcher at VUB, the Vrije Universiteit Brussel. And they are specialists, Thomas in networks, Barbara in platforms. And so without further ado, let me give the floor to start our presentation on updates regarding network regulation.
I think you should see the presentation soon, and I hope that you can also hear me. If there are questions in the chat, I'm sure we'll come later to them. Yeah, I want to give a little bit of an update and an introduction. Wait, it's not working.
Maybe we should see the problem. I think the problem may be that
no, it is. Okay, it's right.
Maybe we should be sitting, it's destiny.
Yes.
Maybe I should. So briefly, my organization is called Epicenter.works. We are a digital rights NGO based in Austria, Vienna, and have been doing this type of work for over 14 years. And net neutrality was really a founding issue of our organization. So we have been working on this basically since there was ever a discussion in the European Union about establishing digital frameworks for net neutrality. And we've continuously worked on the issue throughout all of the reforms that we've seen around 5G, zero rating, and then the most recent debate that we'll soon touch upon, which is about interconnection, novel issue, or not maybe novel. But first, I would like to introduce the general principle of net neutrality and establish the groundworks. If this is redundant, then please bear with me. I'll try to make this interesting. And the first thing you should know that very basic concept that was first and foremost born out of a technical necessity. When the internet was born, we simply did not have the technical capacity to make real-time decisions about the correctness, the legality of any data package. It was simply impossible to do this in real time. Now, since 2001, I would say, is the concept of net neutrality was actually coined by Tim Wu, back then the scientist who was working with such technology that could make real-time decisions about data packages called internet expansion. So the simple concept of net neutrality was in a way already coined as a defensive concept. But what it actually encompasses is also this differentiation between the internet and other communication networks. In a television, you are a receiver or a sender. It can be both. In a telephony network, there is a central entity that has the control whether you are allowed to make a connection, what the individual price for any connection is. And so there's actually a lot of differentiation between universal general purpose bidirectional communication network and previously what we have seen in this area. And so net neutrality is also trying to protect and conserve what the internet was originally meant to be. The debate is quite old. This is one of the first mock-ups from the Netherlands where the debate of the legislation, but the first country to actually establish legislation was Chile. Then, of course, the debate was also very active in the US, and many countries have followed suit. But maybe take a step back. What is it on a philosophical? Lawrence Lessig once wrote in Code and Other Laws of Cyberspace that the internet is like a daydreaming postal worker that simply moves the data and leaves the interpretation to the applications at either end. And he said that this minimalism in design is intentional. It reflects a political decision. Network design. Net neutrality is in a way protecting against discrimination from the telecom operators. every piece of pipe that makes up the internet is owned by a private company. But yet, the internet is more than the sum of its parts. And protecting exactly this universality of the network is what the concept of net neutrality tries to achieve. And there are two types of discrimination, commonly referred to. The first is technical, to slowing down or speeding up certain data transmissions, or also modifying the data. For example, replacing advertising. And there's also the way to economically discriminate by making certain data volumes cheaper or more expensive. And one core concept is also innovation without permission. The layered architecture of the open internet allows innovation on all of the layers without any support from the layers above. You can run email over a copper connection with a dial-up modem or satellite internet. It really doesn't matter. You can start a new application, a new app or website or whatever you deem innovative without really any permission. You are reachable globally from day one. And that was also the benefit or the curse of this young man creating Facebook.com. And he actually paid $85 for the server to bring his service to life. And this is the cost of innovation that is very often. But it's important that net neutrality, and I'm coining the CEO of Mr. Donald Trump will take over the White House and will most likely abolish the concept of net neutrality, made a statement in a shareholder call that the shareholders of networks shouldn't worry because they are now big enough to survive even without net neutrality. Net neutrality always protects the small actors, the fringe actors, who are not able to pay, who are not able to negotiate deals with the companies. We see the most drastic diversions from net neutrality in the form of free basics, product from Meta that replaces the internet in many countries. There are enough studies to really prove that in the minds of many people that have limited experience with the internet, actually, if you ask them, have they used Facebook, more people say yes than would answer, have they used the internet in these things. So this is not just technical discrimination, it's also on the cognitive level, replacing the concept of what the internet is. And if you think about, for example, a very common example here in Brazil, I think, is limitation to WhatsApp. If fake information spreads via WhatsApp and is received by people that have such an internet connection, or such a basic connection to Meta, they are incapable of that. They are technically barred from clicking on the link, let alone having independent information, verifying information they receive. So this is really an amplification chamber for fake news. And that is very dangerous. And I would say it is intentional on the side of Meta to also proliferate their services, given that their RPU is lower than Google's. This is a way to still increase the revenue, but just bring people into the advertisement system. Then there is also something that I just need to mention, device freedom is also part of it. The way in which we connect to the internet is left to us. We are allowed to connect via any type of phone, free software operating system, anything that is networked can connect to the internet. And it is not just the neutrality of the pipe, it is also the ability to connect to the pipe with whatever device is capable of supporting common standards. A lot of the debate was also about specialized services, and can I touch upon that in the legal analysis if we have time for it? I've heard so much on that because it was a centerpiece of the European debate. We will enter into the whole specialized service debate soon again with 5G. If 5G ever really comes, I don't think it will because it's faster internet, but there is still a lot of push from the telecom industry to have vertical integration along the package and differentiate their access services with special access services. And lastly, something that is also very important these days is the question how we are actually bringing the internet together. As it is in the name, this is a network of networks. And often overlooked was the issue of interconnection, how the roughly 100,000 autonomous systems that make up the internet are connecting with each other. This is a map from a few years ago. It is not a galaxy. This is actually a visualization of what the internet looks like. And we see that for the most part, this interconnection regime is a purely technical handshake agreement. 95% of all interconnection agreements are handshake. That means there's no written contract because there's really no profit. This is simply, I need more capacity here, just connect another cable, and that's it. And there are a few very large telecom companies that would like to change that, and that already have the practice in their home countries, like Deutsche Telekom in Germany, for example, where they are really trying to commercialize the interconnection space. And this is really dangerous because it erodes what binds the internet together. It erodes what actually makes this global connectivity possible and level playing field that we have. So let's jump into this current debate about interconnection. Luca asked me to particularly touch on that, and I find it important since this debate has now reached Brazil, and last year there was a consultation of the telecom regulator, and it is also in their consultation document referenced that Europe has agreed to have this or is seriously investigating into this concept. I find it very important to highlight what the actual debate in Europe was like. And the whole thing started in 2022 when Vice Commission President Margarete Vestager came out in support of having for internet network costs. And this idea is not new. This idea was actually discussed a decade earlier, in 2012, at the ITU level. And back then, you still have brilliant slides from Deutsche Telekom where they try to outline this concept. And I still don't understand why they chose a walled-off city as the header image of their presentation deck for the United Nations ITU summit where this was discussed. But the basic idea is very simple. Wherever IP packages money exchange, termination fees are exactly the type of business model that is argued for here. And this is how the telephony system worked, and why we had so little competition and such a natural oligopoly. Because whenever a call is received, the terminating network would receive money, termination fees. And this is widely seen as a horrible concept of competition. If you have the biggest amount of customers, you can make a lot of money by sitting on your hands. But simply keeping your customers reachable brings you revenue. And you have a double-sided market. You have the retail payments from your own customers, and then the termination fees from whoever tries to reach your customers. So heavily skewed on the side of the incumbents. And this same system is now trying to push through on the open internet. This is how it works right now. You have a consumer that wants to reach some service, and then traffic, and Deutsche Telekom would envision that there is now a second tier that is paid, in which there would be higher quality of service. This is actually something that is lacking in the current debate. But besides there being data exchange, there should also be money exchange. And it is very important to pause here and question one actually paying. The customers paying for access to the internet, not to access to the network of Deutsche Telekom or any telecom. Netflix, Facebook, YouTube, they are not unilaterally sending data. They are sending this data on request of a paying customer. So all of the data that is received into the network of the telecom company is already being paid for by their subscribers. Yet this idea was brought up. There was a lot of debate a decade ago, and there was a wholehearted agreement that this is really stupid idea. We're not going to do it. So the telecom industry, ECMA in particular, and also the GSMA Association were using that battle back then And for some reason, now this whole concept is coming back. It used to be called sending party pays or sending party network pays, and now it's called fair share, network tax, network contributions. There are various buzzwords flying around. And it is all that ETNO has commissioned, and which they are basically saying, oh my God, we poor telecom providers only make this is unfair. This is the basic argument behind this. And of course, these two business models are absolutely incomparable. Digging holes and having physical infrastructure is something for pension funds. You know, this is a low risk, low reward business model. And this is simply not the case for many of the internet-based e-commerce services. The other argument from those few big American tech companies. There is no country in the world where this graph is true. These are global numbers. In every country, you would have local broadcasters, mostly public broadcasters, making a sizable share of that. Pornography in almost all countries is double or triple the size of Netflix. So there are many other services that are local that would also have to pay. It would be above certain. Using these global numbers. And even within them, of course, anyone who uses a cloud company who's using a CDN to distribute would be somewhere mixed into any of these companies. If you look at the 4.18% of Apple, that's also privacy relay. Apple is tunneling most of the traffic from their devices via their privacy relay, VPN-like service. So it's almost impossible to attribute traffic volumes on the interconnection level, where most of the traffic is encrypted, to any one particular company. But nevertheless, there is now also, of course, other studies. Analysis Mason has done this brilliant graph where you see that the actual OPEX and CAPEX, so money spent by telecom companies, is mostly a flat line over the years in terms of what they spend to keep up their network. But yet the traffic that is achieved by this, the capacity that we push through the networks, is a stark increase year by year. And router for more or less the same money, but because of technical innovation, you always have more capacity that you can actually deliver. Think about Google routers. Those have not drastically increased in price, but yet the amount of bandwidth that you can achieve with it has, of course, drastically increased. So it is a myth that there are variable costs attached to data volumes actually being hired through the networks. We see the pandemic has proven this. There's even with an over average increase in data volume, there wasn't really any issue with keeping the networks stable. Another very interesting graph here would be that if we look at the internet traffic, of course, video makes up 72%. It's a lot if you think about HD 4K video. This is really the traffic intensive stuff, but it only makes up 2% of the revenue trading. Most of it is search and e-commerce. So if you then tax internet traffic, Amazon, Google would love. Google, of course, with the exception of YouTube, but if you really want a fair redistribution, then you should tax them. And I'm all in favor of that. I think the current situation when it comes to tax implication is horrible and needs to be tackled, but we cannot achieve any meaningful regulation that's fair if we focus on interconnected traffic. And so to summarize the problems, net neutrality gives us all a right to use and offer services in whatever way we choose, and that would simply be impossible if we had such a concept like network taxes. And whenever caps have to pay, there is the big question of what happens if we don't. We are talking about millions, if not billions, according to the telecom industry, that should be achieved by this. Of course, there will be litigation. Of course, there will be fights. And so you always have to ask the question, if customers actually have the right to connect to whatever service they want, and then the service has to pay to make that happen, what is the else that will happen? And our argument here is based on the European net neutrality regulation. And we made this argument in 2022 when Vestager came out of this with this support for the concept. BEREC has now agreed 4 times. So telecom regulators are in absolute concurrence with civil society here that this would absolutely violate net neutrality. As I mentioned, attribution is a big problem. Disney Plus doesn't operate on its own networks. So any CDN, no matter the size, would not be attributable. And then we have the important economical argument that transparency in total is lacking in the interconnection market. I would actually be very willing to change that. We mostly rely on leaks or privileged information. In Europe, the telecom regulators have now started a specific scheme to consult the market in a confidential way, so that basically people can break their NDAs in order for the regulator to get a better. So this is really an opaque market, and we simply have not the information to immediately regulate. And then lastly, and that is such an important argument to make, it's great that we as a society is making it. But again, the telecom regulators agree, why regulate if it is not fair? This market is healthy. This market has worked and scaled for decades. Why should we regulate it? It is simply, there is no basis for it. Anyway, we came out heavily criticized members of European Parliament agreed with us with an open letter. We had more and more pushbacks also from member states. Several high-level member states came out very early on saying, no, we're absolutely not going to do that. Yet France, Italy, and Spain kept on pushing and support, at this point, Commissioner Breton, who is now in charge of this issue. Vestager has kind of recused herself, removed herself, and stayed silent, and also will not be part of the next commission, most likely. So now it is Commissioner Breton, former CEO of Lohninger, who is still pushing for this idea. Important to say that Italy has since dropped out of politics. So we have a minister of Italy responsible for telecommunications on record saying, no, it's a horrible idea, we're not going to do it. All of the big video companies, the Voice Online, Digital Coalition, came out against it. And it's, by the way, important. Disney is not on here, but they have since also joined the chorus. And it's very weird for people like us who are very often on copyright issues on the absolute opposite debate, suddenly be on the side of Mickey Mouse. And then there was also brilliant studies by Wikicom. When suddenly you had a stark increase in homeschooling, all the children were at home. The biggest e-learning provider for universities in Germany suddenly had a capacity problem. So students at home, homeschooling, could no longer hear their teachers, could no longer access their education material. And what was the response of Deutsche Telekom? Of course, we can connect. You just have to pay. And by the way, their rates for interconnection are 50 times more than market average. So this is the actual behavior even before we regulate. So I would argue that the fair behavior here is certainly not what the big telecom providers are, because they are the only ones not peering to the common good of everyone. Small ISPs have come out against this idea, particularly those who invest a lot in the network. This whole idea in Europe is pushed with the argument that we have our connectivity goals for 2030 and we need to reach that. That's why we need the money. There are so many things wrong with that. First, the ISPs that are actually building out the network say, no, this would hurt us more than it helps. Second, we have studies from several regulators on the European and national level saying money is not the issue in Europe. If you want to build out a network, it's permits and it's civil engineering. Those are the cost-driving factors that limit the build-up, but it's actually not the money. There is too much money in certain areas. So if you have a limited number of civil engineering capacities and more money, prices will simply increase. That's already what's happening here. And the consumers, of course, joined us, World Association of all consumer organizations, heavily criticized the idea. And lastly, Euroids, the internet exchanges, who are extremely important stakeholders in this whole debate, because those are the guys who are actually creating interconnection networks all the time. It's their daily business. And the German D6 is the global market leader. And they say, guys, if you do this, we'll lose the resilience of the internet. We will not be able to scale if another pandemic hits or any other unforeseen event that puts us at home. And so they really say, please don't do this. And they would be the ones who have the best insight in the market. Lastly, to summarize this blog, there was a huge consultation from the European Commission, the public record of which is extremely insightful because you see basically all society disagree with the concept except the very large telecom companies. And there's a public record, everyone can validate that. We had in June of 2023, Telecom Ministers' Council meeting in which, according to sources, Breton left him with a red head because he was so angry that, like, the ministers basically told him this is not going to happen. But yet he kept on pushing, and more money was poured in. There isn't a month with at least 2 meetings from the telecom industry, high-level lobbying meetings, the ones with the good food and the champagne. This idea is still being pushed. So there was another consultation whose deadline just ended late June from the European Commission. Mind you, this is after the election. So the strategy of Breton is right now to bind the hand of his successor. And right now it looks like that this will mix together with 5G and more come back next year to haunt us. So has so far not gone anywhere, and we could prevent legislation because that was clearly the path that was foreseen by Breton. But they are not giving up. There's too much money at stake for the telecom industry, and so you can expect that Europe will continue this debate. And tomorrow, the consultation of BEREC, the telecom regulators, ends on their have a 5th statement from the telecom regulators by the end of this year. And there were some more emojis actually here with a few country flags who are not in there. So I wanted to talk about the Brazilian situation. Brazil and India, the telecom regulators, Anatel and TRAI had public consultations in 2023 on this issue, and it was basically tipping the toe into the debate. I'm not aware of any clear positioning, but I know that there were debates and happy to have.
There was no position. There were debates and no positioning, and basically the large telecom operators, they all agree that there is, in their view, need for fair share, and let's say that the regulator is somehow sympathetic to what they agree. The position of the large telecom operators. But again, here, exactly in Europe, they are the only ones that are suggesting that there is a need for this. But there is one academic that also agrees with them. But let's say that people have doubt on the reasons why he agrees with them.
If things work similar in Brazil than in Europe, then I would really look closely at funding of this one.
Which is what reason why people suspect that this academic is not really totally impartial.
So the Brazilian situation then sounds similar to the Indian one, also the consultation, and most likely there the issue will be mixed into the reform of the telecommunications code. There was a draft bill on that a few months ago. And then lastly, South Korea needs to be mentioned. Korea has this idea already implemented, and they have seen devastating consequences. A reminder, Korea has 100% fiber to the home penetration. There isn't a house without a fiber connection. Yet now gamers are complaining, and the latency goes up and the quality goes down. So South Korea has had actually a perfect network infrastructure, and they intentionally destroyed it with this idea. The big content providers are no longer appearing within the country. They all let the South Korean telecom companies do the round over with Japan and now all into Tokyo Internet Exchange. And now it's more expensive for the Korean internet companies to get the traffic from there. And it's also much more burdensome for the internet users. For any real-time application, you can already see this. And of course, the domestic internet cost for hosting and CDN service provider is South Korea is always at the top of all goalposts because it's so expensive there to bring traffic into the internet. And I would have so many more slides on the legal comparison, but I think we are mostly running out of time. Just very briefly, I'm happy to come back to this in the Q&A, but if you look at all of the net neutrality legislations around the world, you basically have some building blocks here, zero rating, traffic management, and whatever constitutes it. The second, and then transparency, scope, and enforcement are the other very important factors for meaningful comparison of the outcomes. And I've looked at the three biggest legislative blocks where the FCC there is no subsequent regulation enforced. There was an updated order, but the Sixth Circuit Court in the US has paused the implementation of that. The next hearing will be on August 5th. And it is very much unclear whether we will have net neutrality in the US. And that's irrespective, of course, of the US election in November. But anyways, the motivation of the whole thing in the US was much more freedom of expression. And if you look at the consultation, you can also see statements from citizens like connecting to other. Very strong sentiment out of a freedom of expression and American identity issue. Whereas in Europe, it was much more like, oh, this makes economic sense. We want to avoid fragmentation, so that's simply do. And we already had two countries with neutrality laws before the EU adopted its regulation in 2015 and it came in force 2016. And India, of course, is the most interesting one, where it really came out of the Facebook Zero dispute. What is today 3 basics. And it was also the motivation that you hear from people is digital colonialism. We didn't want others to influence how we use the internet. And it was actually a regulatory decision by TRI that has been now made into the license regime for any telecom operator, which is an interesting way of enforcing it. But again, like, they might put it into the law if the telecom code in India's reports. Last 2 minutes on zero rating. India really led the way globally when it comes to that because they have the clear-cut definition of all things. Like they started with zero. All of the other countries, China, the US, Europe, we all kind of ended up with zero rating as part of the legislation. India started, and they call it discriminatory traffics. We only had a case. Rating was widespread. Think about Binchong from T-Mobile. So it was not really something that was ever clearly banned, sadly. And we also have scenes like AT&T sponsored data, where a big content provider can pay to have their data seen. In Europe, of course, when we, here the slide is a little bit off. You can go back into the public record. And zero rating is illegal in Europe. And there's also a huge report that we did analyzing the first 2.5 years of enforcement. I'm going to skip over that last year. That might be very relevant for the Brazilian situation, the Canadian regulatory proceedings, because they were specifically looking at the situation when it comes to connecting the unconnected, how zero rating could or could not be a remedy against it. and they came to a clear conclusion that it is not a remedy in any meaningful way. And it is not a sustainable solution for the problem. We've also brought this case intensively in the Colombian High Court, Constitutional Court case that Elente has brought forward. I had the privilege of being an expert witness in that case. It's still pending. We really have high hopes for that. If Colombia were to decide against zero rating, I really would hope that this could be a landmark case for many other Latin American countries. And California, I'll leave you with that. Basically, most forms of zero rating are prohibited. Virtual is allowed. And I don't have the current legislation in Brazil, but I would love to also add it here to the comparison table. And looking at the time, I think
I have some comments and questions, but I think it would be maybe better if we go to the presentation and have a debate.
Okay.
All right. How about we want to leave?
Yeah, my presentation is already there. I
It's
don't
already
know how
there.
to do it.
Let's find the glass.
Okay.
For weeks.
Yeah.
Right.
yeah, it says to Luca.
Okay.
Station, you.
Yeah.
Just a second. One there.
I don't know if my presentation will be more interesting than the previous one, but I hope so.
It'll be as interesting.
As interesting as the other one. So today I'm going to talk about a little bit about the regulation of digital infrastructure in the EU and how the Brussels effect has been evolving around this regulatory package. So just a brief introduction. I'm Barbara Lazarotto. I'm a PhD researcher at VUB. I'm a part of Brussels Privacy Hub, and I'm here representing LSTS.
If you want to.
Okay, yeah, because this is not this one. What's the one?
Is it plugged in? I don't know.
Should work.
For speed.
I think the
Luca from the future.
yes. That's the reason.
Okay.
Sorry.
Esse Questão não tá vendo só.
foi, acho que eu perdi para fechar.
Okay. So first I will start with the context about the digital package, that it's a multi-layered one, and then I will go to the Brussels effect that has been going on so far, and then the future of the Brussels effect as well. But the future is most likely a speculation. Okay. So the multi-leveled digital package. So as we know, that the EU has been regulating the digital sphere as in general for a long time already, over a decade. So the first, we have previous regulatory measures, but this form of package started in 2015 with the digital single market strategy. So with this, we had the directive, the protection directive before, but with the 2015 market strategy, we had the GDPR and the other regulations like the law enforcement directive and the one for the European bodies. So they, as Thomas said, it was grounded in unifying and creating homogeneous internal market for the digital sphere. But then we had the 2020 European data strategy as well. That aimed as well to create this internal digitalization, emphasizing data sharing for the European economy and society. So the idea is that there is a multi-level package that should work together. We still don't know exactly if they work together or not, but more so it's like this. So the first base layer is the article, the base, it creates the ground for the other regulations. So, and then we have the 2015 Digital Single Market Strategy, GDPR, etc. And then the new one, which has the Open Data Directive, is not a part of the Data Strategy Directive package, but I put it there just for the sake of visualization. So we have a bunch of different regulations that have somehow the Brussels effect outside of Europe to other countries. So how they started. So the first layer in Brazil specifically, so we know that Brazil, just as the European Union, considers the fundamental right to data. I don't see this as a Brussels effect. I just see this as a main point of convergence between the two different legal systems, because I think Brazil has a different look at this through the Constitution, 1988 Constitution, but it's a ground that permits the Brussels effect to get into Brazil. I don't see this a problem. For example, in the US, we have the Brussels effect in California, and they don't have this fundamental right to data protection, but this is a very interesting connection between the two frameworks that I think it's relevant. So the second one is the famous Brussels effect of the GDPR. As we know, GDPR was considered to be the golden standard for data protection. So I believe that you know better than I am, I know about this, is that one of the main key points for the Brussels effect of the GDPR is the extraterritoriality of the GDPR. So it forces somehow the compliance with the GDPR outside Europe, so it's kind of forcing companies to comply with it. But I also think the data transfers, the Chapter 5 of the GDPR kind of forces the other countries to comply, or at least have some kind of data protection framework. And Brazil is working on this. I don't think it's out yet, the agreement, right? But they are working on it. So it demonstrates how the GDPR has this European, this Brussels effect. So we have the famous one, the LGPD, which was clearly influenced by GDPR, but also had some adaptation for the Brazilian context, which is the topic that I want to emphasize here, that we don't need a Brussels effect for the sake of influencing other countries, but we need also an adaptation to the context that they are influenced, such as in Brazil. So here we have so far the Brussels effect. We have this comparison between the GDPR and the LGPD, which is a very interesting research. So this by One Trust and Batista Luz Advogados in 2019. So out of the 24 topics that were covered, 15 are kind of similar, 8 are inconsistent, and just 1 is completely consistent. So you can see that the GDPR has indeed influenced the LGPD in greater sense. I think when it comes to enforcement, it's kind of different, but in general, the principles are more or less the same. So when we're talking about the AI Act, so the Brussels effect, so far we have the AI Act. I think that AI Act it's a very big buzz about that Europe wanted to regulate, to be the first to regulate AI. They did it. I don't know if this is a good bad decision. I don't think so, but it was good anyway. But it was an intentional movement to create again this Brussels effect by the Commission, especially for the Parliament. I think from my understanding, just the idea of wanting to regulate AI is already a type of Brussels effect. Although the regulatory measures of Brazil, it's completely different from the EU's. I think it's a good thing, but just the idea of discussing this is already a kind of Brussels effect in my view. So here we have the two different parts of the Brussels effect of the AI Act. So the Brazilian proposal is quite different from the European one because it mixes, so it combines a right-based approach with the risk-based approach, which is very interesting. It is something that we discussed in Brussels in that our event. So because the main criticism in Europe is that we don't have an AI Act that is a right-based AI Act. Then some people that say that there are lacking rights for individuals, data subjects, while others discuss that we have GDPR, so we don't need more rights. They're already there. The Brazilian proposal thinks differently and goes into a mix, so rights-based and risk-based approach. And they create this hybrid supervision structure, which we were discussing, which is the SIA and the multiple level supervision authority of AI. Whereas in Europe, Europe decided to follow somehow the same structure as the GDPR. They have a just risk-based approach. So probably you have the high risk, low risk, and medium. So the high risk is the one that the AI Act is mostly focused on. From our point of view in our event, we saw that, and also in our panel, the enforcement is one of the problematic things. The Act created, gave the member states the option to create an AI supervisory authority or designated this competence to any authority. One good example is Spain, that was pioneer, created the Agência Espanhola de Supervisión de la Inteligencia Artificial. But Italy, for example, splits the competence between two authorities. So we already know that this is kind of going to be a very complicated future for the Brussels effect of this. But also, as Felipe said in our panel, I think the thing that we must take into consideration is that we have the Brussels effect before the Act. So we must take that into consideration as well. It's something that I wrote there. So it's already a result of the Brussels effect. So we have this multi-layer system might be influencing somehow in some ways that we don't know what is going to be working. So going further to the other regulatory measures, which is the DMA, DSA, Data Act, Data Governance, how they are going to influence Brazil. That's something that we don't know, but I'm trying to create something here. So the Digital Services Act, it's a new regulatory measure. It was approved, aims to create. It's a more regulatory for the consumer point. So I see there is a very interesting connection with Brazil because Brazil has a very strong consumer protection law. So it protects users from the internet, for example, from legal content. It creates rules for platforms to remove fake news, for example, disinformation and other types of illegal content. Creates some comprehensive protections for users. And creates basically enforces fundamental rights online. So I remember that when they are discussing the DSA, Breton specifically, it was like, if it's illegal outside of the internet, it's also illegal inside the internet. So it's kind of creating this. In Brazil, we have also a Brussels effect of this, which is the Brazilian law of freedom responsibility, which is the fake news law, which has been a very discussed rule that I know that is now under discussion. I don't know if you are still following this project. They're still discussing, right? Nothing. It's closed now.
Kind of
killed the project and are working on something new.
Yeah, they create a new commission again to discuss this project. So
As they said in the Soviet Union, if you don't want to solve a problem, create a commission.
yeah, so they created the commission. They created the commission. So yeah, but the previous this project cited the DSA clearly 25 times in this justification section. So it was clearly influenced, but we have a different political environment in Brazil, which I don't predict that there will be a very strong Brussels effect of the DSA in Brazil. I don't think so. So here we have the action from Google was very different that they had in Europe. So I don't know if you are aware of this. Google had this, and there in the search bar, you already could see this blog post about them that they lobbied against the project. Also, Musk recently was criticizing the Supreme Court of Brazil and some specific judges about that. So you see that the environment in Brazil is more, not that Europe is against lobby, it's completely not the case, but I guess in Brazil it's stronger in the public opinion than in Europe. We can discuss further reasons after. I think it's a good discussion actually. DMA. So DMA, it's instead of focusing on the consumers, they focus on the companies. So they create basic market rules for the companies. So it's more based on competition law. So it's ex ante measure, whereas in competition law in Europe, it was deemed to be more not very efficient in this case of the digital platforms, which has it's a case by case situation. So the DMA aims to force some measures such as, for example, data sharing between search engines and the multiple market measures to create competitive and fair digital. So they create the famous gatekeeper. So the commission has this proposal where this route that they designate certain companies called gatekeepers, which is, for example, Google. Here again, the Brussels effect has been observed. So we have a project which has been largely inspired by DMA, but we have it's still a project. It's not very famous apparently. I didn't find much about it. So this project 2768. So also aims to create some kind of gatekeeper name. So instead of calling gatekeepers, they call crucial access control power to the companies. But it's exactly the same. So these companies are the gatekeepers. But interestingly enough, they place enforcement in Anatel instead of CADE, for example. So it's a very different, it has a different focus than the competition law DMA that we have. I found this paper who criticizes a lot the measures of the Brazilian DMA, says that in this quest of imposing a Brussels effect, so they kind of got lost in translation. So it's a very interesting paper to explore the DMA. Last but not least, my favorite one, which is the data. I think not a lot of people are talking about this, but I think this is very relevant when it comes to Brussels effect. So Data Act has been approved, was the last proposed regulatory from the data strategy, and it was the last to be approved. Aims to allocate value, so we stimulate data sharing between connected devices. So it comes from IoT devices, but also can include phones, can include tractors, can include a bunch of different IoT and connected devices. So basically, it creates, it forces some data sharing measures from to business to consumer, business to business, and business to government. Also create some rules for to design of the product itself. So you have to create somehow a way to access the data, to consumer to access the data, either through USB-stick or a cloud management or something like that. So it goes directly to the design of the project, but also has some rules about cloud sharing. So it's a very interesting regulatory measure. One of the key points that I don't think people are not paying attention of, it's about the new requirements for non-personal data, which is Article 32 of the Data Act. And I think this has a very big impact outside Europe, which is to basically a trend to non-personal. So somehow, we don't know exactly if this order that they said that if a third country wants to access non-personal data held by the Union, would be sufficient to have a adequacy decision in the shape of the GDPR, or they need a new one to do that. There's no discussion about that. There's little written about this topic. I presume that since the GDPR is considered to be a golden standard for personal data, that would be sufficient, but we still don't know exactly how it's going. So it's basically enforcing new measures for non-personal data, which can impact the sharing between Europe and Brazil, for example, data spaces and switching clouds. So it's a very interesting article that people are not paying enough attention to. So I think this has a very big impact. Oops, sorry. Huh? Okay. I don't know why it happened, but I still have it here. The last slide. Okay, so we have future challenges related to the Data Act, which are the mixed data sets, because the more you share IoT data, we have personal data that in theory, the Data Act demands that you separate, but sometimes it's not possible. So my theory is that that's why they created Article 32, because since they cannot separate the data set, so let's protect all the data sets, it's for personal and non-personal data, so let's create this rule that protects both, kind of the same way. We also, how Brazil should interpret these rules, because we have different trade secrets protection rights, we have different competitive rights, we have different contractual rules here in Brazil and in other countries. So how they're going to interpret this demands for sharing data so openly from the Data Act? Are they going to follow the same path of Europe? I don't think that's possible anyway, but it's going to be applicable from next year, September next year. So yeah, a lot of things to think about. So thank you very much. Can I close this?
Yes.
Okay.
We want to start with comments for questions. Live streaming, is live streaming?
Yeah, I think so.
Yes, live streaming. So let's have polite comments and questions and get live streaming on, and then we can have more confidential comments and questions. Now, one comment I had is that actually regarding the zero rating here, the fact that we have several telecom operators here using the same talking points that Europe use. But there is, I think, a very stark difference. In Europe, the revenues of telecom operators have somehow plateaued over the past decades. So they are stable. Not saying that this is inefficient, but they are not growing. Because here they have benefits of 5 to 10% every year. So there is no economic rationale to say we are losing money because large tech companies are free riding, because the economic data demonstrate that they are earning money, even if there is, of course, large presence of GAFA, let's say, in the national network. But again, why there is this large presence? Because since 8 years they have been zero rated by the same telecom operators and complain about the fact that they occupy too much traffic. So at the same time, it's sort of schizophrenic behavior, but at the same time, they complain that social media consume too much bandwidth, but they are subsidizing social media. So if you don't want them to consume too much bandwidth, stop subsidizing. So that was a first comment. The second, actually, I personally have for Barbara or for you also, if you are aware about the implementation of data spaces. This is something that is interesting for us to understand which kind of how data space in practice can or have been implemented. And I'm curious about this. I don't know if you have been working here or hearing about this. If so,
If you want to do,
Yeah, so we have been working on the European Health Data Space, which I think is the only one that actually has been concluded, to my knowledge. The financial data space was proposed, and I don't think it was adopted in the previous term. And those data spaces are, as we just heard about the Data Act, and I think another piece of the jigsaw puzzle is the Governance Act that is related to personal data and governs how it is anonymized, pseudonymized. They're actually, from a mathematical point of view, I am very unhappy with that law because as an adversary, I would still see many ways to re-identify people. But setting the Data Governance Act is law of the land. And it leads to a situation where the European Health Data Space is obliging the primary use of health data, go to the doctor, hospital, pharmacy, but also the secondary use of data for pharmaceutical research, among other things, where suddenly it is highly dangerous to see sensitive health data in the arms of profit-oriented companies that could easily re-identify individual circumstances. The timeline for the real implementation of the European Health Data Space is very long. I think the last deadline is 10 years. That was mostly because of Germany. You know, they have a very fractured IT health system. The Nordic countries, as soon as role model, you can expect within 1 to 3 years to already have all of the health data space components in implementation there. And in, for example, my country in Austria, the projects are now picking up steam. They are slowly trying to get a grip of what it is that they have to do. And it's important to say that European Health Data Space, like many other health data spaces, are lex specialis to the GDPR. So they are the exception to.
Yeah, it's actually when it comes to because doctors are obliged to share the data, which is kind of the opposite logic that we thought about the GDPR, right? So it's kind of an opt-out, not opt-in kind of logic of the European health data space, especially.
but you can opt out.
Yeah.
No.
No, yeah.
There is a provision that allows a member state to constitute an opt-out for primary use of data and theoretically also for secondary uses of data. But then the regulation foresees certain conditions, for example, statistical purposes, where even an opt-out from the secondary use of data can be overridden by the health ministry. So it's not meaningful opt-out. That's why the law only passed with a sharp majority. And we were heavily opposed.
Questions, comments?
Maybe an observation in the comparison between different instruments. Exactly, the Data Governance Act doesn't have an equivalent version here, but there is a legislative proposal on the creation of an ecosystem of monetization of personal data, which is a bit strange, but basically would create an entitlement to receive some money value in exchange for allowing devices, softwares to access your personal data. And then you could prohibit that and make use of the blockchain to make sure that this is not accessed without your permission. Of course, this is a bit problematic. I think that the fact that the proposal includes a specific technology, that so could be doubted that it's sustainable to apply to the whole array of data that are made available when you're using digital technologies. So I'm skeptical of the particular implementation, but it's still an early proposal, so it will probably be subject to interesting amendments, and maybe it will become a law as well. So I think it will fit into this mapping that you're doing.
I should have added also the DGA as well, because I think it's a very relevant regulatory measure. Yeah. Especially when it comes to the data spaces. I have a question, if I can. I don't know much about net neutrality, but as from your presentation, I came to the conclusion that the Tron is basically pushing this for lobby reasons because everyone is against it. Is this?
Yes.
Okay.
There's a clear conflict of interest. He put his own shares in his former company in a trust. But I mean, it is clear from the public records of the transparency register that he has far more means to develop the industry than any other group. And on this particular issue, we as a society of the opinion that this is our play and not according to how you should regulate, because nothing of this is in the work program of the subsequent last term or in any of the years where it was worked on. There is no clarity of process. You have an overwhelming rejection, yet the idea is still kept alive.
Yeah.
And this is really the worst of what Europe should do. I mean, to pick up the Brussels effect, I mean, we also learned last week that there is something like a leaking effect. Of course, if you are a strong economic bloc, you can regulate those big companies and others might follow. It doesn't mean that the regulation is good. And here we have seen that Europe is not at all looking at, we're not even talking human rights. This is about competition. This is about doing favors to one industry to the detriment of even media pluralism. Like we have media regulators saying this is really bad for diversity. And still the idea is kept alive. So
it's similar to the chat control. Because at least the chat control, the children, you have some kind of other part that has an argument that is more so standing, whereas in this case, nobody is agreeing with it except the large.
That's almost, I think it's related. So why did it come back? Because you said like it's been many years this debate and now it has come back. I understand that in the US there was this big consultation and there was a huge pushback against it. But now again we are talking about, is it because 5G makes it more important to think about the allocation of traffic? Will it become more of a thing in the future maybe? Is this why it's coming back so strong?
I think we have to look at all of these regions a little bit in separation. In the US, the debate is heavily partisan. If you're a Republican, you are against net neutrality. If you are a Democrat, you are for it. And the Republicans use argument this net neutrality silences conservative voices. I still have not logically followed the argument. Like if you give everybody a voice, it's bad for conservatives. I don't get it. But these are statements that you hear in the public debate. And since Trump is one of his first moves, annulled net neutrality, it is very foreseeable that shouldn't be re-elected, that this is the trajectory the US will be on. Even if he is not, right now the Sixth Circuit in the US, who's actually not responsible for this, still decided to keep the case. Whereas normally the Washington District Court would be the one in charge of all telecom regulatory affairs. And the Sixth Circuit has a judge who's a Trump appointee. So even in the legal system, the net neutrality issue in the US could become polarized. And this is not even looking at the underlying question of the annulment of the Chevron doctrine. I'm not a legal scholar in the US, so I cannot foresee how this will play out, but the annulment of Chevron doctrine could mean that the whole ability of the FCC to regulate this area is out. I mean, there is a clear legal basis for classifying internet as common carrier as they did. So, but it's definitely going to be interesting. Your question also asked about the motivation of the telecom industry, and Luca is absolutely right. In a growing economy, you would normally have other means to gain revenue. And it's very hard to say you are subsidizing traffic that on the same side as cluttering up your network. Like the argument already in Europe makes no sense, but if you have strong zero rating, it makes even more no sense. Yet they try also in India. So the telecom industry is very clear. You can also see this in Barcelona at the annual meeting of the telecom industry. This is clearly now a GSMA strategy. It's in the play. They will try it wherever they can, and there's a lot of money pushing in there. The ultimate goal is push the business model of the telephony era onto the internet. We want to make money from both sides.
The court said that zero rating is a violation of the neutrality. Then you would say the same about this proposal. No?
Yeah, I mean, in Europe, I would be very optimistic that the ECJ would come to this conclusion. In Brazil, in Colombia, we were so sure to win this case because all of the arguments were in our favor. And normally, after an oral argument, the court decides maximum within a year. It's now been 8 months or something. So it's above normal that this court is, the issue was always in the public calendar, but yet not decided. So colleagues in Colombia think that maybe there's also a push from industry to not have such a judgment. But legally speaking, from a human rights perspective, I think the case.
More questions, comments? All right. So round of applause. Now we can switch off the Zoom broadcast so that we can have credential comments and questions.